गुड इवनिंग। आज लग रहा है आप लोगों ने नाश्ता वाश्ता किया है। हाँ, actually it is the duty of those who have the liberty to stay at home to take care of those who actually are nomads. So anyways, so we'll be revisiting what we have done yesterday, and then we'll be okay. Subhash Kashinath Mahajan case, Kaushal is asking. So actually, in Subhash Kashinath Mahajan case, the Honorable Supreme Court ruled that under SC/ST Prevention of Atrocities Act 1989, a case will only be registered after a preliminary inquiry has been done by an DYSP rank officer about the veracity of the complaint, or prima facie or at the face of it, whether the complaint looks genuine or not. Second thing is that no arrest can be initiated until the senior superintendent of police gives a permission. So this actually, in CRPC, the investigating officer has absolute powers to proceed with the arrest if the what you call the offense is a cognizable one. So this was a what you call some additional qualification that was added by Supreme Court, and the Parliament of India, amending the SC/ST Act, has done away with this. Okay, okay. How many of you are taking prelims 2022? शर्माने की क्या बात है इसमें? आप सेंटर पर चेहरा ढक कर थोड़ी जाइएगा। दो लोग, इतनी बड़ी क्लास में सिर्फ 2-3 लोग हैं। ओके, हाँ, मुझे मालूम है और भी लोग हैं। Compoundable offenses are those offenses, Rahul, where the investigating officer does not require a warrant from the magistrate to initiate arrest. Okay? And non-compoundable, needless to say. Okay. Cognizable offense, sorry. अच्छा, compoundable पूछ रहे हैं. Compoundable offenses are those offenses where compromise can be reached, and non-compoundable where compromise cannot be reached. So, okay, what do you mean by this? That act is not applicable on SC/ST. Act is not applicable on SC/ST means if there is an offense of untouchability or any offense which has been prescribed in the act, if the same is done by a person who belongs to scheduled caste or scheduled tribe community, then the case shall not be raised. This act is only applicable on those who do not belong to scheduled caste and scheduled tribe category. Okay, so अब इसी पे शुरू हो गया, ठीक है. Do reservation promote in my opinion. अब opinion discuss करें. In my opinion. अच्छा, जैसे contemplative mood में नहीं बोलता, मैं सोच रहा था. He says in that movie ना, डैड मैं सोच रहा था. इसे तुम सोचते भी हो? Okay, just kidding, don't mind. Okay, so article 16, we started with article 16. अब ये कल का है, तो अब इसको तो रिवाइज नहीं करेंगे, 2 दिन पीछे हो जाएगा फिर. So article 16 deals with public employment. Public employment में which grounds it is prohibited: religion, race, caste, sex, place of birth, place of residence, and descent. Then in public employment, the state can make provision for the advancement of socially and educationally backward classes and SC/ST. And also the state can make those public offices where religion or associated with a religious denomination, a person professing that particular religion can be appointed. And later on, 10% reservation for economically weaker section, up to 10% reservation for economically weaker section, Also that the reservation shall be provided in promotion for SC, ST, but it has also been ruled by Supreme Court that it is not a fundamental right, it is a provision which the state may or may not accept. Okay, so this is what we did in Article 16 of the Constitution. Did we write? Nahi na? We wrote also. Okay, 17 also we wrote. So then we had Article 17. This question is likely to be asked this year. Reservation in private sector. Okay. So if we target around 35, 40 questions, undoubtedly 6, 7 questions would be asked from there only. So Article 17 of the Constitution, untouchability, new changes to the Act and Supreme Court judgment. Okay. So we have, अब इसमें कुछ चीजें हैं, consequential seniority. Okay. जरूरत नहीं है यार, फिर आधा घंटा, ठीक है, उतना आपसे कॉन्सिक्वेंशियल सीनियोरिटी, कैचअप रूल, ये सब जुडिशरी में भी दे डोंट आस्क. ओके, सो कोई जरूरत नहीं है. सो वी हैव आर्टिकल व्हाट यू कॉल 18 ऑफ द कॉन्स्टिट्यूशन. यू ऑल आर हैविंग ओनली वन क्लास एवरी डे. तब क्या है, फिर क्यों? देयर आर मेनी बैचेस आई एम टेकिंग, पीपल आर हैविंग 2 क्लासेस. हाँ क्या जी? टेस्ट कौन सा? मिनी टेस्ट फिजिकली यू हैव टू बी देयर. वेयर इज इट कंडक्टेड? हाँ, ओके, यू कैन गिव. अच्छा अच्छा, थैंक यू फॉर अपियरिंग फॉर द टेस्ट. आई along with my family extend. So Article 18 of the Constitution. Okay. So Article 18, कोई नजर नहीं लगाएगा. Okay. So Article 18 of the Constitution can be classified into 4 parts. Okay. One, it is a bit, this question actually, Article 18 has been asked in 2021. And from where they have lifted the question, that also I'll tell you. छुपा दिया है. ऐसे ही मेरा वक्त सही नहीं चल रहा है ज्यादा, इसलिए कोई नजर नहीं, तबीयत ठीक नहीं है. ओके, सो यू हैव आर्टिकल 1, 2, 3, 4. सो आर्टिकल 1 of the Constitution says that the state shall not be conferring any title other than military or academic. So Article 18, just for your convenience, I am dissecting it in 4 parts so that you understand like anything. Okay? State shall not confer any title except military. Oh, military or? So other than military or academic, no title shall be conferred by the state. No title. यानी कि राय बहादुर, खान बहादुर, सर, getting my point, any such title shall not be conferred by the state on anyone. Indian state shall not confer title on anyone except military title, Param Visht Seva Medal, PVSM, Lieutenant General, Colonel, whatever titles, military or academic titles, like if you are a medicine graduate, so then you enroll with medical council and then you become, you can have prefix doctor before your name, or if you have done doctors in philosophy, that is PhD, then you may have doctor as a title. Okay, so PhD karke doctor. Otherwise military or academics chhodkar you don't have any what you call title. Any problem? So India, the Indian state shall not confer any title. Second, Indians cannot accept any title. So first part is from a foreign state. So India will not confer any title, and Indians also cannot accept a title from a foreign state. Third, any person who is not an Indian citizen but working in an office of profit or trust in India, he will also not accept title from a foreign state without the permission of president. So a foreigner working in Delhi Metro Rail Corporation, which qualifies as state, he or she will not accept any title from a foreign country without the permission of president. And finally, anybody, Indian citizen or a foreigner who is working in an office of profit, we will deal with office of profit. It's a beautiful topic. We'll deal with that. Office, simple language, any governmental post other than the post of minister. Okay, that is not qualified as office of profit, shall not be accepting any gift or emoluments, मतलब कुछ और gift तरह का तोहफा, perk, any such thing without the permission of President of India. So Article 14 can be classified into 4 parts. One, that the state shall not award any title except military or academic. All such titles, Netaji, Behenji, Didi, all these titles are not given by the state, but the people call out of love and respect for their leaders. They call these names. It is not given by the state. So no title can be awarded except military or academic. Second point, Indians will also not accept title from a foreign state. So if England or United Kingdom wants to confer a title of Sir on Sachin Tendulkar, he cannot accept that. Third, any foreigner who is working in India in an office of profit or trust also cannot accept title from a foreign state without the permission of president. Fourth is not related to title. Any gift, emolument or any such thing will not be accepted by a person who is holding an office of profit or trust in India. Okay, so these are the 4 classifications. Now 2 more things I will show you. Okay. One is from where they have asked a question this time. 2021, how they ask question, I'll tell you how. Whenever you are reading about an organization, spare 25 seconds, just go and see check in to the website and visit About Us. Okay, About Us, undoubtedly any organization which is in news this year or was in news last year, it will take 2 minutes only. Go and visit the original website, About Us. They are lifting questions from there. Okay, like they have lifted a question from here. So this year they have lifted in 2021, they have lifted a question from here. It says that Bharat Ratna, how many awards are given in 1 year? So it is 3. Okay, there was one option. Second, the awards have been discontinued only once. Okay, so the awards have been discontinued twice. Okay, so yahan it is written is except for a brief interruption during year 1978-79 and 93 to 97. These awards were not given. So this also was a statement in prelims 2021. They have lifted from the direct About Us home par jaakar, that is the website of Padma Awards. Okay, so this was in news last year. Okay, so they asked a question. Now we will see the Constitution of India and we will directly see Article 18 kya keh raha hai. You see Article 18. First it says, no title, is it visible? No. No title not being military or academic distinction shall be conferred by the state. Yani the state shall not be conferring any title except military. Second part, no citizen of India shall accept title from any foreign state. Yani Indians will also not accept title from those countries who actually give title. Then you have no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of president any title from a foreign state. So third is, those people who are not Indians working in India in an office of profit or trust cannot accept any title without the permission of president. Fourth is a general one. No person, matlab irrespective of the nationality, holding any office of profit or trust under the state shall without the consent of president accept any present tofa, any perks or any office of any kind under the foreign state. Okay, so this is the fourfold classification of article 18. First point. Second point, ki Padma awards are awards, they are not titles, and this has also been ruled by the Supreme Court. They were stopped briefly during the Janata Party government in 1978-79 and during the Congress regime and post National Front government from 1993 to 97. So they have been discontinued twice, and maximum 3 people can be given Bharat Ratna every year. Okay, and these are awards, not titles. In awards, you know, there is Padma Shri, Padma Bhushan and Padma Vibhushan. Okay, so this is there. Okay, they are very smart, they can ask next year also. Okay, so all these things, the one point over here is ki you can also nominate yourself to be awarded. If you feel that you have performed worthy, you are worthy of the award, you can nominate yourself. Okay, so this is the thing. They can give a confusing statement in prelims, but Padma awards, यहाँ क्या लिखा है? The award does not amount to a title and cannot be used as a suffix or prefix to the awardee's name. You got that? नाम के आगे या नाम के बाद आप अवार्ड, जैसे पद्म श्री सचिन तेंदुलकर cannot get his visiting card printed as Bharat Ratna Sachin Tendulkar. It is we who will call him Bharat Sachin Tendulkar. He cannot use it as a prefix or suffix. So why do you think this provision has been added in the constitution, specifically in fundamental right? And this is a positive right or this is a negative right? Negative right. And why this provision has been added? To avoid arbitrary distinction in the society. The Britishers, you all know, you all come from different background. You see ki in rural hinterland, the Britishers used to give title to the people Rai Bahadur, Khan Bahadur, Sir, to those who were actually, you know what they were. Okay, so the point is ki they were close and they were serving the British interest, they were given, and these titles create arbitrary distinction in the society. What about the title of Mahatma Gandhi? RTI was filed with Ministry of Home Affairs that who has bestowed the title of Mahatma Gandhi to Gandhiji, so it's father of the nation. So Ministry of Home Affairs replied that the state has not conferred any title. It is the people of this country who out of love call him father of the nation. Okay, so this must be understood. Okay, so this is all we have to do with respect to Article 18, which is undoubtedly one of the smallest one, but UPSC in last 6-7 years they have asked twice because of the controversies associated with awards. Okay, undoubtedly awards, but now that they have asked, so maybe they may not ask so what you call at regular intervals, but nothing can be said. So please write Article 18. Article 18. The state shall not confer any title except military or academic. Except military or academic. Next you write the Constitution further prohibits the citizens of India from accepting any title from a foreign state. Then you write the 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 constitution further prohibits the constitution further prohibits any person who is not a citizen of India, any person who is not a citizen of India, further prohibits any person who is not a citizen of India but holding any office of profit or trust from accepting title from any foreign state without the consent of president. Next you write, this is a very pertinent point, कि any person who is holding office of profit or trust any person who is holding office of profit or trust any person who is holding any office of profit or trust cannot accept any present or office cannot accept any present or office cannot accept any present or office of any kind from a foreign state without the permission of president. Full stop. आगे लिखिए. The Supreme Court in Balaji Raghavan versus Union of India case. The Supreme Court in Balaji Raghavan versus Union of India case. The Supreme Court in Balaji Raghavan versus Union of India case ruled that national awards such as the Supreme Court in Balaji Raghavan versus Union of India case ruled that national awards such as, what are the 4 national awards? Bharat Ratna, Padma Vibhushan, Bhushan and Shri. Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. Are constitutionally valid and they are awards, not titles. They are awards, not titles. ठीक है, आगे लिखिए. Although the recipient का मतलब recipient cannot use these awards as prefix or suffix. Recipient cannot use these awards as prefix or suffix. ठीक है, पूरा अब कोई क्वेश्चन बन ही नहीं सकता है. थोड़ा हम वेबसाइट से लिख लेते हैं उनकी कुछ बातें. They are very smart. They can ask the same question twice. Okay, so please write. And if there is a Persian couplet, I don't exactly remember, it's like Azmudara, Azmudi, Azmudan Khatast. It means that आजमाए हुए को आजमाना सबसे बड़ी खता है. So if you have been cheated, betrayed, or felt cheated or betrayed, then if you are giving that person a second chance, so it is not his fault now, it is your fault. Okay, ये तो आपने नहीं, it's Persian, so you may not have heard, but this तो you have heard. This is in many languages you have the traditional wisdom. Okay, so there is another one for you actually. This तो you must have heard. मिटा दो अपनी हस्ती, गर कुछ मर्तबा चाहो, कि दाना खाक में मिलके गुले गुलजार होता है. Well, let me tell you. मिटा दो अपनी हस्ती मतलब shell of your identity. गर कुछ मर्तबा चाहो, if you want any recognition in the society, कि दाना खाक में मिलके मतलब the seed loses its existence, गुले गुलजार होता है, then comes the garden. You are getting that? So okay, so we have अमीन लोग का चलेगा, ठीक है? Okay, so we have, please write maximum 3 Bharat. This question also has been asked. Maximum 3 Bharat Ratnas. Maximum 3 Bharat Ratnas can be announced in an year. Can be announced in an year. Okay, then you write the awards were constituted in 1954 and subsequently renamed in 1955. Constituted in 1954 and subsequently renamed in 1955. Okay. Then you write the award is conferred after the nominations are scrutinized by a committee headed by cabinet secretary. Scrutinized by a committee headed by cabinet secretary. Full stop. Next you write. Okay, next state मतलब state and center both. महिमा भारद्वाज, it is both state. Article 12 में जो state का definition है. Next you write, the Prime Minister recommends the President the name submitted. Recommends the President the name submitted. Okay, so this is what you call, अब हो गया, this is more than enough, everything. हाँ, ये लिख लीजिए, one can also recommend himself or herself. One can also recommend himself or herself for the award. For the award. For the award. Okay. So you have what you call Article 19 of the Constitution. Article 19 of the Constitution is brutally important. क्या लिखा, क्या छूटा लास्ट में? Okay, so Article 19 is brutally important and this is undoubtedly the most favorite area where questions are asked. Okay, first of all, Article 19, please see what all articles are there. We will see. ये एकदम आना ही आना है question. Every second year they are asking a question from Article 19. Directly, indirectly, it is very, very important. Okay, so you see Article 19 of the Constitution. It says all the citizens shall have right to. First is speech and expression. Okay, so we will deal with first Article 19(1)(a), that is speech and expression. So there is a fundamental right to speech and expression. Second point is that it is also pertinent to understand that भाई सीट चेंज कर रहे हैं आप क्यों दिल पे ले रहे हैं चलिए सुनिए. So Article 19(1)(a), freedom of speech and expression, is one of the most important article. It also includes right to remain silent. The Supreme Court has ruled that freedom of speech and expression also include right to remain silent, and speech means anything that is said by verbal ways. And expression has been what you call interpreted by Supreme Court that any form of communication, it may be by sign, it may be through WhatsApp, Telegram, Messenger, or any other form you are communicating, that is form of expression. Okay, so and what is the statement of Supreme Court? That freedom of speech and expression is and dissent. You always understand why fundamental right to freedom of speech and expression has been given. Why? It has been given for you to speak something good or speak against or have your own independent views. Just imagine that if you are saying something that pleases me, so will I be angry or happy? Happy. So you don't need a fundamental right to say something which makes me happy. If you say something which makes me happy, I will not feel sad at you or angry at you. You need a fundamental right precisely to say something which makes the government dissent, right to dissent. It doesn't mean that you will start writing in your answer, but I am saying the Justice D.Y. Chandrachud, in one of the famous lines in recent times in privacy judgment of Supreme Court, K.S. Puttaswamy versus Union of India, says that dissent is the safety valve of democracy. Dissent is the safety valve of democracy. For example, democracy is a pressure cooker. In a pressure cooker, you have a whistle. If you press the whistle deliberately and does not allow it to come up and release the pressure, what will happen? The pressure cooker shall burst. So dissent is that safety valve of democracy which allows the democratic institutions and setup and political entities to stay. Okay, so dissent is the safety valve of democracy. So what all points have come first? Freedom of speech and expression. Speech means saying something by verbal communication. Expression has a wider manifestation. Second, it also includes the right to remain silent. Okay. Third important thing is that it also, freedom of speech and expression also includes cinematic expression, which has all forms of art. Any book, any movie, any such form of expression is also included in this. And next, just imagine that why it has been added in the Constitution. If you want to say something which pleases me, which makes me happy, you don't need a fundamental right for that. I will not do anything as long as you are saying something which makes me happy. You are given a right to say something which may make the government or the authorities uncomfortable. That is the beauty of democracy. So dissent is the safety valve of democracy, this famous statement given by Justice Chandrachud in Aadhaar case. Okay. Next comes the point that whether it is qualified or it is restrictive. So now you will understand whether it is qualified. Qualified ka matlab, while you enjoy those rights, certain qualifications are there. You cannot say anything. So it can be restricted on certain grounds. Fundamental rights in United States of America is relatively more absolute, while in India they are more qualified, keeping in mind the socio-economic, ethnic, cultural, religious and national integration, all the challenges and factors in mind. These fundamental rights in India are in restrictive sense. Okay, so let's see what are the grounds on which it can be. So it says nothing in sub clause A of clause 1. यानी सब क्लॉज ए ऑफ क्लॉज 1 ऑफ आर्टिकल 19 क्या है? 19(1)(a. What is it? Freedom of speech and expression shall affect the operation of any existing law, already if there is a law, or prevent the state from making any law. State can make any law also, far as such law imposes reasonable restrictions. So always the court will be checking whether the restriction imposed by the state is reasonable or arbitrary. It is the duty of Supreme Court and High Court, the two powers, that the two courts only in India that have the power of judicial review, to check whether the restriction is reasonable or unreasonable. Okay. On exercise of the right, conferred by the said subclause in the interest of the sovereignty and integrity of India. So you cannot say something which affects the sovereignty and integrity of India. The security of state, friendly relation with foreign states. So if we have a friendly relation with foreign state, you must be vigilant to say something about those states also. Public order, decency, morality, okay, and relation to contempt of court. Contempt of court is avmanna. There is a civil contempt and there is a criminal contempt. It is a topic we'll do in judiciary. Defamation. You know, defamation may IPC 499. Truth is also not a defense in defamation. I told you that day, I think. Truth is also not a defense in defamation. For example, somebody committed pickpocketing in Delhi. Finally, he was convicted. He went to jail. He came out. And now he thought, I'll live a different life. He traveled to Kerala. And there he is living a different life. Nobody knows that he was. You went to Kerala. You saw him. And you are telling everyone. So there you are saying truth. But truth is also not a defense in defamation. Defamation case can be filed against you. In many of the cases, truth has not been accepted as defense if you are trying to malign the character of someone. So now, contempt of court, defamation और incitement to an offense. अभी मैं announce कर दूं incitement to an offense. समझ रहे ना? कोई भी ऐसा आप में से ही कोई कोई भी ऐसी बात. So you see the fundament freedom of speech and expression. So what is the position? Is it very absolute or restricted? Huh? So what are the grounds? Huh? Half kg at least. Okay. So you have what are the grounds? Reasonable restrictions. Interest of state, sovereignty and integrity, security of state, friendly relation with foreign states, public order, decency, morality, contempt of court, defamation, incitement से बचने के बाद आप speech and expression exercise कर सकते. Okay, so these are the grounds on which other fundamental rights में grounds are actually not this much. Okay, the very limited restrictions are there. I told you United States का Texas versus Johnson. So the level of absoluteness in United States is much more. It is because of our own socio-economic and other regions. So these are the reason on which fundamental rights can be restricted on freedom of speech and expression. Now section 124A of the Indian Penal Code. Okay. So it deals with sedition. Okay. Whoever by word or by any means excites dissatisfaction against a government established by law. So sedition is one such provision which has been in controversy. For it has been, first of all, it was brought by a British regime. Second, those countries which have enacted sedition actually have done away with it. They don't have sedition anymore in their domestic laws. They do not have sedition in their laws. Okay. Third, Mr. Gandhi, Bal Gangadhar Tilak ji, great freedom fighter, Gandhi ji, these people were arrested under section 124A of the Indian Penal Code. And Gandhi ji said this in the courtroom, that I am happy to be arrested under section 124A. It is the queen of all the IPC sections when it comes to repression. It is the queen of repression when it comes to all the sections of IPC. You are getting my point. So section 124A has been a matter of debate, but undoubtedly you will write a very balanced and nuanced answer that at the same time it must not be misused, but the kind of diversity and challenges we face in India, it is absolutely pertinent for it to be stayed there. Okay, so stay it, but it should not be misused. So so freedom of speech and expression has a very, very wide connotation, and there is also current affairs we have dealt. Central Board of Film Certification. Okay, that is the body which which has been established by Cinematograph Act, and there is a recent amendment proposed to Cinematograph Act giving certain powers to the government. So that let's have once the amendment will be passed, then we'll see. So it is in discussion stage. So that also you always see कि फला state ने ban कर दिया movie को. You hear ना कि this Padmavati, so Padmavat. So actually it was banned in many states. So who is the authority that gives certificate? It is Cinematograph Act empowers the Central Board of Film Certification to give certificate. So how states are actually banning? So actually the state can restrict freedom of speech and expression. Movie is also a form of freedom of speech and expression because the state can restrict in the interest of public order. But the Supreme Court has time and again come down heavily that any form of expression must not be curtailed. Okay, so must not be curtailed, and the authority that is actually empowered, Central Board of Film Certification, all of you must have seen before the movie starts that. Okay, so you can also make a movie and get a certificate. That's not a tough deal. Okay, so this is something which is there. Then comes the right to press. Okay, Constitution of India has not conferred any right to press explicitly. The Supreme Court in Bennett Coleman case, Bennett Coleman actually is the organization which owns Times of India. You must have seen right in the front, on the front page you will see Bennett Coleman Limited. It is written, and two elephants you must have seen. So actually Bennett Coleman were I think they were the people who were owning Times of India. When India partition, they left, giving the family, present family, which owns. So actually Bennett Coleman case में Supreme Court ने कहा right to press is an important part of freedom of speech and expression. Justice Venkat Chalia Commission, the commission to review the working of Constitution, said that Constitution should be amended and freedom of press should be incorporated as a explicit fundamental right or a constitutional right. Okay, as if now there is no mention of press freedom in the Constitution. It is under Article 19(1)(a). Okay, so that is Article 19(1)(a) of the Constitution. In one of the cases, Supreme Court said that mere shouting of slogan does not lead to sedition. Mere shouting of a slogan, Fala Zindabad or whatever, does not lead to, it must lead to incitement of an offense. So sedition laws must not be used in an arbitrary, unreasonable manner. Another very important case we have already discussed, that is Information Technology Act 2000, Section 66, capital letters A, which empowered the police to file an FIR if an information was decimated, information decimate हो रही थी कि किसी भी technological medium से. So I told you a lady posted on Facebook, another friend of her liked the post, and they both were arrested. So a lawyer, law graduate, law student actually moved Supreme Court challenging the constitutional validity of Section 66A as being violative of Article 19(1)(a). Why? Because Article 13 क्या कहता है? Article 13 कहता है any post constitutional law must not violate fundamental right, otherwise it will be void to the level of contravention. So article in Information Technology Act 2000 Section 66A is violating Article 19(1)(a). So that section of the act was declared unconstitutional in Shreya Singhal versus Union of India. So Article 19(1)(a) से related बहुत ज़्यादा literature है. क्यों? It is very very important. But you must remember that this is not an absolute right. This is a qualified right, and so many grounds are there on which the state can restrict your fundamental right, but every time such restriction should be reasonable. And who will check this reasonability? The court, Supreme Court as well as High Court. Okay, one last thing that must be, that can be asked over here with Article 19(1)(a), what is written in 1? Unnecessary question. Flying Sikh. Flying Sikh कोई award उनको title मिला था, and title, it is was the title given by what you call state. It was a title which was given by what you call a person who called himself. I'll call him Babua. So अब वो state, he will become. If I'll call that person as Babua, whether it is a title that is being given. Thanks, friends. Okay. So friends, chai pee lo. So the point is, it is all citizens. Okay, so this question can also be asked in prelims, that this Article 19(1) is only to be enjoyed by citizens. एक और चीज इसमें करेंगे, when Article 19 can be suspended. When Article 19 can be suspended, this also we will do from mains point of view. Please write Article 19(1)(a). Okay, right? First, A छोड़ दीजिए, पहले एक general line लिखिए. Article 19 is only available to the citizens of India. Article 19 is only available to the citizens of India. Full stop. आगे लिखिए. it is Article 19 is only available to the citizens of India, then you write it is not an absolute but qualified right. It is not an absolute but qualified right. It is not an absolute but qualified right, full stop. Now you write small letter a, speech and expression. Speech and expression. Speech is verbal communication while expression has wide manifestations. Speech is verbal communication. Speech is verbal communication. Speech is verbal communication while expression has wide. Speech is verbal communication while expression has wide connotations. Speech is verbal communication while expression has wide connotations. Okay? समझ गए? Next you write the speech is verbal communication while expression has wide connotation. Next you write the article also includes right to remain silent. Also includes right to remain silent. Then you write it can be restricted, reasonably restricted. It can be reasonably restricted on following grounds. It can be reasonably restricted on following grounds. क्या क्या ग्राउंड है लिखिए ए या वन जो भी आपको लिखना है पॉइंट वाइज. What are the grounds on which it can be reasonably restricted? So first you write what is the ground. First round is sovereignty and integrity of India. Sovereignty and integrity of India. Sovereignty and integrity of India. Then you write security of state. Then you write friendly relations with foreign state. Sovereignty and integrity of India, security of state, friendly relations with foreign states. Then you write public order. Public order. Then you write decency or morality. Decency or morality. Then you write contempt of court. Decency or morality. Then you write contempt of court. Then you write defamation or incitement to an offense. Defamation or incitement to an offense. Defamation or incitement to an offense. Okay? हो गया? Next you write major issues. Major issues. First you write sedition. Sedition. Major issues, sedition. Section 124, capital letters A of Indian Penal Code. Section 124A of Indian Penal Code. Provides for Section 124A of Indian Penal Code provides for the offense of sedition. Offense of sedition. Okay, let's see it. Let's see it. Okay. It says whoever by words either spoken or written, or by signs or visible representation or otherwise brings or attempts to bring into hatred or contempt or excites disaffection towards the government established by law shall be punished with imprisonment for life, to which fine may be added, with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Liberty hai court ka. Okay? The expression disaffection includes disloyalty and feeling of enmity. Comments expressing disapprobation of the measure of government with a view to obtain their alteration do not constitute. मतलब अगर कोई demand कर रहा है, all these things they will not constitute. So you are getting, this is section 124A that deals with sedition. So please write, what did you write? Section 124A provides for sedition. Next you write the Supreme Court in Kedarnath Singh versus State of Bihar. The Supreme Court in Kedarnath Singh versus State of Bihar. The Supreme Court in Kedarnath Singh versus State of Bihar ruled that the Supreme Court in Kedarnath Singh versus State of Bihar ruled that sedition will only be applied. The Supreme Court in Kedarnath Singh versus State of Bihar ruled that sedition will only be applied if there is actual violence, or incitement to violence, there is actual violence or incitement to violence through written or spoken forms, actual violence or incitement to violence through written or spoken forms. Full stop. आगे लिखिए, in Balwant Singh case, there can be a mains question on this actually. In Balwant Singh case, the Supreme Court ruled that mere shouting of slogan does not excite. In Balwant Singh case, the Supreme Court ruled that mere shouting of slogan does not excite hatred or dissatisfaction. Mere shouting of slogan does not excite hatred or dissatisfaction. Mere shouting of slogan does not excite hatred or dissatisfaction. Okay? Justice D.Y. Chandrachud, CHUD है. Justice D.Y. Chandrachud also famously stated, inverted comma में, dissent is the safety valve of democracy. Justice D.Y. Chandrachud also famously stated, DISSENT, dissent is the safety valve of democracy. Dissent is the safety valve of democracy. ठीक है? Dissent is the safety valve of democracy. अब लिखिए आगे, सिनेमैटिक एक्सप्रेशन. पहला तो सेडेशन था, दूसरा सिनेमैटिक एक्सप्रेशन. फर्स्ट वाज सेडेशन ना, सेकेंड इज सिनेमैटिक एक्सप्रेशन. सिनेमैटिक एक्सप्रेशन, सिने, CINEMATIC, cinematic expression. The Supreme Court has categorically stated that any form of art categorically stated that any form of art cannot be unreasonably restricted. Any form of art cannot be unreasonably restricted. Any form of art cannot be unreasonably restricted. Next, you write online content. Online content. Please write the Supreme Court in Shreya Singhal versus Union of India case. The Supreme Court in Shreya Singhal versus Union of India case. (2015) struck down section 66 capital letters A. 2015 struck down section 66 capital letters A of Information Technology Act 2000 as being unreasonable restriction as being unreasonable restriction on Article 19(1)(a), as being unreasonable restriction on Article 19(1)(a). Okay, then you write freedom of press. Freedom of press. In Bennett Coleman case, B-E-N-E-T-T, Bennett, C-O-L-E-M-A-N, B-E-N-E-T-T, Bennett Coleman case, the Supreme Court ठीक है, B-E-N-E-T-T, Bennett, C-O-L-E-M-A-N, Coleman, Bennett Coleman case, the Supreme Court ruled that in Bennett Coleman case, the Supreme Court ruled that freedom of press is implicit in freedom of speech and expression. Freedom of press is implicit in freedom of speech and expression. ओके आगे लिखिए, ये भी एक और केस ऐड कर लीजिए, जस्ट केस लिखिए. इन दिस इज अ फेमस केस रिलेटेड टू राइट टू होल्ड फ्लैग होस्टिंग. विच केस? हु वाज द पॉलिटिशियन हु फाइल्ड अ केस इन सुप्रीम कोर्ट कि राइट टू होस्ट फ्लैग इज अ फंडामेंटल राइट? पहले आम आदमी नहीं कर सकता था, बस जाइए किसी फंक्शन में वहां. So now you can also host flag. Which politician? Very famous case. Naveen Jindal. Very good. लिखिए, किसने बोला? हाँ सही, एकदम सही. लिखिए, in Naveen Jindal case, the Supreme Court upheld the right of a common citizen. In Naveen Jindal case, the Supreme Court upheld the right of a common citizen In Naveen Jindal case, the Supreme Court upheld the right of a common citizen to host flag. Okay? So we have written major aspects of Article 19(1)(a). Next, just write a concluding statement. Freedom of speech and expression. Freedom of speech and expression is an important facet of democracy. FACET. Freedom of speech and expression is an important facet of democracy. Freedom of speech and expression is an important facet of democracy wherein the is an important facet of democracy wherein the right to express dissent, where the right to express dissent is implicit in it. Where the right to express dissent is implicit in it. Okay? Ho gaya? Done? So we have done a great deal. Okay? So now it is Article 19(1)(a) only. Now we'll go to Article 19(1). अभी 19 का भी 1 का A ही चल रहा था. Okay. Now we have what is Article 19(1)(b)? It is right to assemble peacefully without arms. Okay. So इसमें भी cases हैं. First of all, on what grounds it can be restricted? So let's come to clause B के restriction किस किस ground पर हैं. So what are the grounds on which clause B? Clause B के restriction है sovereignty and integrity of India, public order, बस दो ground. So your right to assemble peacefully without arms can be restricted in the interest of sovereignty and integrity of India and public order. So इसमें grounds कम है. So right to assemble peacefully without arms. Now the question arises, what about बंद? So बंद मतलब भारत बंद, यूपी बंद, X state band, Y state band, calling of band by political party. Every now and then, Supreme Court says it is unconstitutional. Why? Because it impairs the economic life of the country and it impinges on someone else's fundamental right. I have a fundamental right to travel throughout the country. There is a band called and you are stopping me from moving. So actually, bands are unconstitutional. Okay? What about strike? It is one of the, in labor law actually, there is a paper in law, strike has been very exhaustively discussed. So many cases on strikes. So actually strike is not a fundamental right. Strike is not even a right. But it is not that everything in the world is right. Something can exist, but it is also not illegal. Okay, there is a world in between also, na? For example, you are walking by the pond. You saw somebody drowning and calling for help. You smiled and said Tata. So actually, does that person has a right that you should save that person? No. So it is ethically correct. It is neither illegal nor legal to save. It is not explicitly provided and neither illegal. There is a world. People wanted the Supreme Court to declare that right is a fundamental right. So Supreme Court says that right is not a right, strike is not a right. But it doesn't mean that it is illegal. Industrial Dispute Act 1947 has provisions related to strike. And there are many cases where circumstances in which you can go on a strike. First, there will be a negotiation with the management. After that, there will be a tribunal. If you fail to talks fail, then you go on a strike. Okay. And many a times the Supreme Court has declared these strikes as illegal. Jaise banks. Okay, because it impairs, it is very too much of what you call issues are there. And Essential Services Maintenance Act, ESMA, you must have heard, there is an act where the government can force the employees to go back, get back to work, otherwise all of them would be dismissed from service. Okay, why? Because it's essential services maintenance ke liye government can actually force. So strike is not a fundamental right, not even a right per se, but there is a provision. So circumstances are taken. Circumstances are taken that under which some, but bands are unconstitutional because they impair the economic life of the nation. Your right to assemble peacefully without arms can also be restricted under section 144 of CRPC, which you must have heard since childhood, 144. So it is empowering a magistrate to prohibit any unlawful assembly. Unlawful assembly is defined in section 141 of IPC, 5 or more people. So magistrate who is the in charge of law and order, if he is of the view that this particular assembly will be detrimental to public order, so he can prohibit that under section 144 of the criminal procedure code. So this is all you need to understand with respect to right to assemble peacefully without arms. Okay, please write article 19(1)(b). Kaushal again is asking, he is asking many questions today. So I will compile all of them and publish as questions. So the point is, please write article 19(1)(b). It is right to assemble peacefully without arms. Right to assemble peacefully without arms. अब असेंबल भी होना है, आर्म्स के साथ भी होना है, इतना कॉन्स्टिट्यूशन. Now you write this can be restricted on which grounds? Sovereignty, this can be reasonably restricted. On grounds such as sovereignty and integrity of India, sovereignty and integrity of India, and public order. Sovereignty and integrity of India and public order. Okay. So this is one ground on which this is done. Okay. Next, you write something about this. Please write the Supreme Court in T.K. Rangarajan case, the Supreme Court in T.K. Rangarajan, the Supreme Court in T.K. Rangarajan case ruled that right to strike is not a fundamental right. The Supreme Court in T.K. Rangarajan case ruled that right to strike is not a fundamental right, comma, statutory right per se. Although there is a provision of right to strike, although there is a provision of strike, बस कीजिए, although there is a provision of strike, although there is a provision of strike in Industrial Dispute Act, although there is a provision of strike in Industrial Dispute Act 1947, although there is a provision of strike in Industrial Dispute Act 1947, wherein it is permitted under certain conditions. It is permitted under certain conditions. Then you write it is permitted under certain conditions. Okay. T for Tamil Nadu. Okay. So it is TK. ठीक है. Next P. ठीक है. No, quite logical. Okay. समझ गए. अब आगे. So this is article 19(1)(a), article 19(1)(b). Then you write. Please write under section 144 of CRPC. हाँ. अरे क्या Okay, the section 144 of CRPC. अरे वही चाहिए, रोटी आ गई, थोड़ा तोड़ के दे दीजिए, खिला दीजिए, फिर एक डाइजेस्टिव कैप्सूल भी दे दीजिए कि इंटेस्टाइन्स को काम ना करना पड़े. लिखिए, द सेक्शन 144 ऑफ सीआरपीसी, द सेक्शन 144 ऑफ सीआरपीसी empowers the magistrate the section 144 of CRPC empowers the magistrate to restrict an unlawful assembly, empowers the magistrate to restrict an unlawful assembly apprehending, restrict an unlawful assembly apprehending, apprehending danger to public order, apprehending danger to public order. Okay. So this is something which is important. Now we have, okay, dear students, we have the third right, that is right to form an association, union or cooperative societies. This has been a controversial one in 2021 because this was added through 97th Constitutional Amendment Act, where Article 19(1)(c) was amended, and right to form an association, union mein it was added cooperative societies. And also it added Article 43(b) under directive principles, cooperative societies, and also Part 9(b) in the Constitution. A greater part of Part 9(b) of the Constitution has been declared as unconstitutional by Supreme Court. Why? Because cooperative is a state subject. Parliament made certain changes related to federal character. It should have got ratified by half of the state legislative assemblies. Any constitution amendment which alters, changes the federal structure, relationship between center and state, or it encroaches upon the rights of the states, then what happened? Then it will be declared unconstitutional. If it has not been ratified by half of the state legislative assemblies, we will definitely do all kinds of majority. Huge amount of misconfusion is there. Yeah, confusion is there in majorities. Right after, I completely think we should have done before only. Okay, but I think that right after this fundamental rights, one thing we'll do is all kinds of majorities and how we'll amend the constitution number wise. Okay, that we'll do. Don't worry about that. So this is actually in news. So right to form an association, union, cooperative also includes right not to join an association, union, cooperative. For example, if there is an association, you want to disassociate yourself. So that is also a fundamental right. It also includes right to continue with that association, union or cooperative. Right to form association, union, cooperative, right not to join association, union, cooperative, and also right to continue or discontinue with that association, union or cooperative. No, अरे ये दिल पे ले लिया. बोला sir, why you said backbenchers are the ये इस पे backbenchers are the intelligent ये best brain of the nation may be found on the last benches of the. First of all, I am actually asking here I am actually asking whether you have understood or not. Second, I am not judging. I never judge. Third, this quote has been attributed to Mr. Kalam, okay, and he was asked also by a girl, and there's Insta clip is also there. So he also replied, okay, so ऐसा कुछ भी नहीं है भाई, इतना फुर्सत कहाँ, बैक बेंचर जो पीडीएफ में नाम आ गया वही फ्रंट बेंचर है, ठीक है, कोई बैक बेंचर नहीं. आई एम जस्ट आस्किंग बिकॉज आई गेट टू नो दैट वेदर यू आर अंडरस्टैंडिंग और नॉट. I cannot interact, I cannot ask question. So it is my duty, they are coming to the class, they must understand, they must be rich by 8 p.m. So that is why I am asking. Okay, backbenchers are, every backbencher is replica of Einstein. ठीक है, कोई बात नहीं, जो मेहनत करेगा उससे होगा. बैक पूरी टेक्नोलॉजी है, आप देख रहे हैं. आई वॉन्ट मोर क्वेश्चंस, पीपल फ्रॉम बैक टू आस्क क्वेश्चंस. हाउ विल आई अंडरस्टैंड दैट वेदर यू हैव अंडरस्टूड और नॉट? You can raise your hand, you can ask questions. And here it is about timing. Many people get free by 4 o'clock. They leave, so they are likely to be backbencher, other than some very intelligent people who just come at 5 and sit at the front row. Just kidding. So it's very good. You take that seat only. So, but this, so otherwise, I know there are multiple reasons. Many of you are working. Many of you are working and you have so many different background reasons are there. Of course, that can be a reason why people are, some I saw come after half an hour. So I completely understand that that person must be working hard till 5 and then came. So there can be reasons. So ऐसा कुछ नहीं है, ठीक है? अब इनका यहाँ पर कुछ भी सो दिल पे नहीं लेना है भाई, इतना दिल पे बिल्कुल भी नहीं लेना है, ठीक है? So you have right to form an association, union or cooperative societies. Okay, please write. YOLO, you only live once. Okay, please write. हाँ, बताइए, पूछिए. हाँ, कोई बात नहीं, यू कैन राइट वी, वही है वर्सेस. ओके, यू कैन राइट वी और वी एस, दोनों सेम ही है. कोई एक्चुअली यूपीएससी, फर्स्ट ऑफ ऑल there is a space, limited space, only 250 words, and the moment you start writing 250 words ends. So you UPSC does not want you to write about the case, just mention the case and what was the most important thing about that case. You are not required to go through, but this also has changed in last few years where UPSC is directly asking a question from case. So they are asking a question from case. Okay, so this you must understand at all costs ki they ask a question on constitutional morality. First you will write constitutional morality, you will quote Dr. Ambedkar, uske baad jagah hi nahi bachegi. And UPSC from 2015 they have started giving you restricted space, kyunki so to avoid them, actually that was the reason they used to write like anything, usse aas paas bhi log nervous ho jate hain. Okay, so the point is कि इसी वजह से they are giving restricted space and you have to write in that. कुछ भी उतना के जीएस में बहुत ही बेसिक मामूली चीजें हैं, बहुत ज्यादा बेसिक्स हैं, पर बेसिक शुड बी एब्सोल्युटली क्लियर. वी हैव दैट टेंडेंसी कि आप हायर नहीं, बेसिक शुड बी वेरी क्लियर. सो बेसिक बस केस का नाम मेंशन कर दीजिए, दैट इज मोर देन. इवन ईयर इज नॉट रिक्वायर्ड. ओके, इफ यू मेंशन द नेम प्लीज राइट. सर यू लाफ लाइक डेनवर फ्रॉम मनी हीस्ट. लिखिए, प्लीज राइट फास्ट. The article 19(1)(c, article 19(1)(c provides for, article 19(1)(c provides for right to form association, union or cooperative. Right to form association, union or cooperative. Association, union or cooperative. Next you write, this also includes, this also includes the right to continue with an association, union or cooperative. This also includes the right to continue with an association, union or cooperative, and right to avoid the membership of an association. Right to avoid the membership of an association. This can be right to avoid membership of an association, union or cooperative. Okay, avoid membership भी लिखे तो काफी है. So this has a right to join an association and also अवॉइड और कंटिन्यू विद द मेंबरशिप, तीनों पैराडाइम है, मतलब तीनों फेसेट उसका कवर होता है. राइट टू फॉर्म एन एसोसिएशन, राइट टू ज्वाइन और राइट नॉट टू ज्वाइन, मतलब कंटिन्यू और discontinue, that all include. This is what I meant to convey. Now you write, this can be restricted on ground of sovereignty and integrity of India, public order or morality. Sovereignty and integrity of India, public order or morality. Okay? Sovereignty and integrity of India, public order or morality. Public order or morality. ठीक है. Why they have added morality? अभी तक तो morality सिर्फ freedom of speech and expression में था, फिर morality नहीं था, अब आगे भी एक दो क्यों इन्होंने ऐड किया? हो सकता है you will form an association, pickpockets association. So is it morally? So कोई भी एसोसिएशन जैसे कि पीपल money heist, anything can be an association. So any such association is morally detrimental. Okay, so morality can be a ground also to restrict an association, union or cooperative. Next one actually is very important, that is right to travel throughout the country. Okay, and that actually is a bit important, because to what extent your freedom to travel can be restricted, and what is the difference between traveling throughout the country and traveling to Maldives outside the country, which is covered in Article 19 and other is covered in Article 21. What are the important facets and all? So it will take a bit of time, so we can go on a break. We'll come back after 10 minutes and we'll do Article 19 1D. Welcome back, student. Let's start. Okay, so what were we doing? 19.1. So we have Article 19.1D, right to move freely throughout the country. Okay, so to avoid any confusion, after the debate in Constituent Assembly, they have added the term throughout over the term within, because the term within may have restricted. The government may have allowed you to travel from A to B but not from B to C. So they have deliberately used the term throughout, if you read the debates of Constituent Assembly, over the term within. Okay, then you have on what grounds it can be restricted. Okay, Article 19.1D restriction same ही ground है, D और E का, ठीक है. So you have Article 19.1D or E. Article 19.1D is right to travel throughout the country. E is right to reside and settle anywhere in the country. So Article 19.1D and E can be restricted in the interest of general public or scheduled tribe. So can be restricted in the interest of general public or the protection of the interest of any scheduled tribes. Okay. Okay. So we have what you call Article 19.1D and E. Okay, so we know about John Allen Chow. Have you heard this name? Huh? You have heard about North Sentinelese Island? Yeah. So there is a place, North Sentinelese Island, where in the interest of scheduled tribe, nobody from outside goes there. You know, they are among the few tribes in the country, in the world in fact, who have never contacted with outside. Okay. So John Allen Chow, a United States national, he wanted to convey the message of God to these tribes. So he visited India on a tourist visa. He went, he paid bribe to the fishermen, and they took him through other route, and he finally reached there. First day they attacked him. Second day, first day they attacked him. Second day he wrote a letter, 14-page letter, to be handed over to the fishermen so that it should be given to his family members. And he said that I'll again carry the message of God, whatever happens, I will not. So he went there and he was killed. Okay, so it became an issue. So why these people are not allowed to interact with the outside world? Why? Why these people are not? Because the first reason is within 24 hours all of them would die, because they have not developed antibodies for virus. So our body has been exposed to all the viruses. Even before 300 years, even the common flu would kill lakhs and crores of people. Now, because we have developed the and you know, there is bacteria can be killed by an antibiotic. Okay, but virus can only be killed by your antibodies that are developed by the body. So since they have never been exposed to any outside, Britisher once went there. He deliberately took 4 people, 2 children and 1 couple. The couple died at Port Blair within few hours, and the children he dropped them back. Okay, because they have not developed immunity to even the slightest of virus. So that also is a very, very important biological reason. Other than that, an anthropologist, Madhumita something, Madhubina Banerjee, she actually contacted with the tribe and handed over coconut or something. Otherwise, they are very, very ferocious. They do not want interaction with the outside world. So you have a fundamental right to travel throughout the country, but it can be restricted in the interest of general public or scheduled tribe. What is a scheduled tribe? It is defined under Article 366. Scheduled tribe is a community as per Article 342. 342 article of the Constitution says that scheduled tribe will be a community that will be declared by a presidential order. Okay, that will be declared by a presidential order. First time the presidential order came in 1950. After that, subsequent amendments are made by the parliament. So there cannot be a separate SC or ST list for each state. Under Article 341 SC list, 342 for ST list, and 342A for OBC list. OBC list can be there of state OBC and central OBC. State government job के लिए state OBC, central government jobs के लिए. But for SC ST there is only one list, okay, that is presidential order mentioning all the SCs of particular state. Any subsequent amendment has to be done only by the parliament. Only parliament can add or only parliament can delete. So scheduled caste and scheduled tribe are described through a presidential order. You are getting that important point, okay? So that is something which is very, very important, okay? So scheduled caste and scheduled tribe are by presidential order. You are okay? So this is under Article 341 and 342, okay? Next is what you call right to travel abroad. So many of you know this also, that this was a matter in Maneka Gandhi versus Union of India case, where the Honorable Supreme Court ruled that within right to life, Article 21 of the Constitution, you have an implicit fundamental right to travel abroad. To travel throughout the country, you need Article 19(1)(d). To travel abroad, you need Article 21 of the Constitution. And also Article 21 is coupled with Article 19(1)(g). I am what you call a pianist or a cricketer or a legal representative. So for my profession, I have to travel abroad. So I have a fundamental right to practice my profession, but it stays incomplete without right to travel abroad. You are getting my point. So you have to travel abroad actually. So Article 19(1)(g) cannot be enjoyed without Article 21 of the Constitution. You are getting my point. So this is something which is very, very important. Article 19(1)(g) is also incomplete without right to travel abroad. Right to travel abroad is implicit under Article 21. Right to travel within the country is explicitly provided in Article 19(1)(d) of the Constitution. It can be restricted in the interest of general public or in the interest of scheduled tribe. Okay, so please write Article 19(1)(d). That is right to move freely throughout the territory of India. Right to move freely throughout the territory of India. Okay. Okay, so right to move freely throughout, liberty to right. What is liberty? Responsible use of freedom under rule of law. Okay. So the point is कि Article 19(1)(d), so you wrote right to move freely throughout the territory of India, full stop. This can be restricted in the interest of, this can be restricted in the interest of, this can be restricted in the interest of this can be restricted in the interest of scheduled tribe and general public, scheduled tribe and general public. ओके समझ रहे हैं ना इंटरेस्ट. और ऑब्वियसली कल्चर भी एक रीजन है, लेकिन ये भी एक रीजन है. कल्चर तो है ही रीजन. See, you cannot allow, the Supreme Court also came down heavily for tribal, what you call tourism. So you just take people, show, so that also has been prohibited. So in securing their culture, that is absolutely necessary. But also there is a biological reason. Centennials would take years to develop that antibodies, otherwise all of them would die. And even census is conducted, they go from outside, from the air, they see that how many huts are there, they average find okay 10 huts are there, so 4 people must be staying, so they write in census. I went and saw it, they have written 200 to 400 like this. Okay, so approximate data. Okay, getting my point. So this is because we do not go there, it is prohibited. So by an order, so issued under article 19(1) D of the constitution. Right? क्या लिखा लास्ट स्टेटमेंट आपने? हाँ, then you write the Supreme Court in Maneka Gandhi versus Union of India. The Supreme Court in Maneka Gandhi versus Union of India. The Supreme Court in Maneka Gandhi versus Union of India ruled that the Supreme Court in Maneka Gandhi versus Union of India ruled that the Supreme Court in Maneka Gandhi versus Union of India ruled that the right to travel abroad, the right to travel abroad, the right to travel abroad is an implicit right under, the right to travel abroad is an implicit right under, is an implicit right under, implicit मतलब जैसे आर्टिकल 21 राइट टू लाइफ इंक्लूड्स राइट टू हेल्थ, राइट टू स्पीडी ट्रायल, राइट टू रेप्यूटेशन, राइट टू क्लीन एनवायरनमेंट, राइट टू शेल्टर, ऑल दीज आर implicitly hidden under article 21. and who expands them? Supreme Court expands them by judicial reviewing or in a case. So it's क्या लिखा आपने लास्ट? Implicit right under article 21 of the constitution. Then you write, right to travel abroad is also imperative. Right to travel abroad is also imperative. Right to travel abroad is also imperative to enjoy. Right to travel abroad is also imperative to enjoy article 19(1). Imperative to enjoy article 19(1) G, that is right to practice any trade, profession, etc. That is right to practice any trade, profession, etc. है कि नहीं जरूरी? अब जिसका काम ही है विदेश जाना, कई ऐसे ब्लॉगर्स हैं वो राइट अबाउट द वर्ल्ड, सो दे विल बी, their job would actually is, you are getting right to travel abroad is implicit under article 19(1) G of the constitution. और सुप्रीम कोर्ट ने यह भी कहा है कि एक राइट अकेले नहीं जाएगी, राइट्स वुड बी इन हार्मनी. 25-26 in harmony, 19-21 in harmony, 14-19 in harmony. हार्मोनियसली दोनों को इंटरप्रेट करके दोनों का चलना चाहिए. ओके, इंडिविजुअल, दे आर नॉट सेपरेट एंटिटीज पर से. ओके, सो यू रोट दिस. नाउ यू राइट right to reside and settle in any part of the territory of India. Right to reside and settle in any part of the territory of India. Right to reside and settle in any part of the territory of India. Okay. So this also has put an asterisk and write has similar restrictions as that of 19.1. 19.1. 19.1 D. Very good. Right. Has similar restrictions as that of 19.1 D. Has similar restrictions as that of Article 19.1 D. इसमें कोई डाउट है? D for Delhi. DELHI वाला Delhi. Okay. Now you write Article 19.1 F. So Article 19.1 F, we all know since childhood that it has been deleted by 44th Constitution. Why it has been deleted पे चर्चा करते हैं, एक एक करके सब कुछ. चलिए. For abolition of zamindari rights. So just tell me one thing. What is the basis of wealth in India today? What are the major sources of wealth in India? Huh? What economy is India today? Every economy in the world has its own feature. Russian economy is oil and defense sector economy. Natural gas, oil and defense sector economy. West Asian economy is oil based economy. Cambodia, Myanmar, Laos, Vietnam is jeans economies. Matlab button, collar ka cuff, pin, small things. India has micro, small, medium enterprises and knowledge economy. Okay, agriculture is barely contributing, get in true sense, the number of people that are unemployed. United States has high-end economy. Boeing 747, Apple, get it? So planes. Western Europe has luxury products economy. Lamborghini, Bentley, Audi, Mercedes, Porsche, all these, Porsche, how do you like in German, Volkswagen. So basically they have their own economy. And so India has micro, small, medium and knowledge economy. So what was the source of wealth in 1950s? The only source of wealth, agriculture. And land was the most. So Article 1938 of the Constitution says that the state shall minimize inequalities in income. Article 39C of the Constitution says economic system does not result in concentration of wealth. So economic system does not result in concentration of wealth or inequality should be reduced. How will you implement Article 38 and 39C? How will you implement Article 38 and 39C? कुछ ज़्यादा ही it is. How will you implement that? 38 and 39C. Don't you think what was the source of wealth? Land. So if you go to take somebody's land, what he will do? He will say land is my fundamental right. So either you implement Article 39C and 38 or you leave it to Article 19.1F. Constant conflict हो रहा था. So in first constitutional amendment 1951 में ही आ गया. Constitution आने के एक साल बाद कि Shankari Prasad judgment. So ninth schedule was added. Article 31A, 31B was added. B में जोड़ दिया any law that is put inside ninth schedule will be immune from judicial review. So 31B has all the land is which subject? State subject. So why land is a state subject? ठीक है? You see all that, हर कुछ common sense है. You have to play with the constitution. Okay. कुछ भी ऐसा नहीं है. Everything that happens around. Okay. So land is a state subject. For example, the union government announces aims. For example, the union government announces aims. So union government, there is always a statement. Union government would say that we have announced an aims for UP. Now who will give the land? UP government. Why will center will set up aims also and it will give land from defense se kaat ke. It has a limited land of defense and railways. So who will benefit from the aims? States. So they will, center will say ki we have given aims, now you give land. We will be running, we will be paying salaries and expenses and other what you call expenditures. So you give, land should be given. Land should be given by you. So now you come to Delhi. Delhi is a union territory where land is not a state subject, UT subject. Land is a central government subject. Why? Every 1 kilometer you have Romanian embassy, Hungarian embassy, American embassy, Pakistani embassy, Japanese embassy, all the embassies. So tomorrow if we sign a diplomatic relation with any country, we say ki we'll give you space for embassy. So every time National Commission for Backward Classes, SC, ST, minorities, women, minority educational institution, सारे के officer for special linguistic minorities, Union Public Service Commission, every single CAT, Securities Exchange Board, you are every single what you call offices, CVC, Lokpal and Lokayukt, all of them are centered in Delhi. So every second day Union government needs a land for a new national headquarter. So every time it will run to UT government to give us land. So that is why land is not kept as a subject in UT list. The Union Territory of Delhi does not have power over land. You are getting my point. But the state have power over land. कोई problem नहीं है. If the central government announces, land will be given by the state. Now you come to Article 19(1)(f). So if you implement Article 38, minimize inequalities in income, or develop an economy where concentration of wealth is avoided. So 38, 39C versus 19(1)(f). To avoid that conflict, Article 31B was added. Ki any law that is put under 9th schedule will be immune from judicial review if they violate fundamental right. So who will pass a law to take land from the zamindar and distribute among the landless? Parliament will pass because land is a union subject. Who will pass? इतना कहानी क्यों बना रहे थे? यही आने के लिए ना कहानी बना रहे, कुछ भी बोलते हैं पहले 5 मिनट उसके पीछे से कहानी शुरू करते हैं ताकि समझें आप लोग. So if land is to be taken from zamindar and distributed among the rural landless to implement Article 38 and 39C, who will pass a law? Because land is a state subject. So land, तो अब Parliament added Article 31B. Law will be passed by state legislature by ordinary majority. Now the Parliament will pick that law and put inside the 9th schedule. So that is immune from judicial. So all the laws passed by Zamindari Abolition Act passed by all the state legislative assemblies were put inside 9th schedule by the Parliament. Okay, so that it is immune from judicial review, and we have to implement Article 39, 38 and 39C. अब उसी में आप we'll see 31B when we reach their 9th schedule and immunity and all. So ये क्यों आया, एक ही साल में क्यों आना पड़ा? Within 1 year of the constitution coming into being, certain laws have to be protected from judicial review so that nobody challenges it as violation of right to. The moment you take land from the zamindar, he will, Shankari Prasad, he was a zamindar. Sajjan Singh, he was a zamindar. Immediately he will move. Supreme Court ki mera 19(1)(f) ka kya hua? You are giving my land to Bhikru. Okay, so where is my right to property? Okay, so actually then the Parliament enacted first Constitutional Amendment Act and added Article 31 capital letters B कि state legislature will pass the Zamindari Abolition Act, Parliament will lift the act and put inside the 9th schedule. Now Zamindar cannot move Supreme Court for violation of fundamental right because any law that is put inside 9th schedule is immune from judicial review. We'll see Keshwananda Bharti IR Coelho case. Later on the Supreme Court said nahi, aisa judicial review se complete immunity नहीं हो सकते. They cannot be a complete immunity. We'll see later. But what is the story behind this? Finally, Parliament का सर खत्म करो, and they deleted Article 19(1)(f) of the Constitution and provided it as a legal constitutional right under Article 300A. No person shall be deprived of his property except by the authority of law. So except by the authority of law, and you cannot move Supreme Court because right to property is no more a फंडामेंटल राइट. पहले हाई कोर्ट जाइए, हाई कोर्ट आर्टिकल 226 में, उसके बाद सुप्रीम कोर्ट आइए, लॉ को चैलेंज कीजिए. किस तरीके से सरकार कॉम्पनसेशन देने के लिए भी बाध्य नहीं है. इफ द गवर्नमेंट टेक्स एनी बिल्डिंग टुमारो, एनी बिल्डिंग, एनी इन लटियन जोन बेसिकली, एनी रेसिडेंशियल, इट विल गिव 1 rupee compensation. That is also enough. Only if it takes the land of a minority educational institution, it has to pay a constitutional fundamental right, it has to pay a market compensation. Or if it takes the land of a farmer which is within its ceiling limit, गरीब के पास थोड़ी सी लैंड है, and you are taking that article 31A में exception है कि गरीब फार्मर की लैंड ले रहे हैं विद इन द सीलिंग लिमिट, then you have to pay him a market compensation, otherwise any land can be taken, 1 rupee compensation will be given. Practically on ground what happens, whenever the government takes the land, huge amount of compensation is given. And you see Jewar airport, that quaint story also. So I also know a friend of mine, his land was taken in UP Agra corridor. So first they gave 32 crores. So somebody said ki protest. So some of them went and protested. Another time they gave 32 crores. So it was like 64 crore rupees, and he's enjoying. Literally, he's enjoying. He went to United States, did his graduation, came back. Now also he's thinking what to do. So he has the liberty to think. Why? Because the state normally gives huge amount of compensation. Okay, क्योंकि state can पैसे की तो कभी सरकार getting my, but if your land can be forcibly taken by a law. Getting my point? So article 19(1)(f) was deleted in the backdrop of everything happening. Finally the parliament said कि right to property को ही खत्म करते हैं, tension ही नहीं रहेगा. And why? After the Keshwananda Bharti judgment, where the Supreme Court ruled that the term law in article 13 does include or does not include? Does not include constitutional amendment. So fundamental rights can be taken away by constitutional amendment. Keshwananda Bharti judgment के बाद parliament became more strong and it deleted article 19(1)(f), which was upheld by Supreme Court later, because it is not the basic structure of the constitution. समझ में आ रहा है? Can the parliament take away a fundamental right by a constitutional amendment? अब पीछे समझ में आ रहा है? Can the parliament take away a fundamental right by constitutional amendment? Yes. And most importantly, subject to basic structure. अब आर्टिकल 14 ही ले लिया, आर्टिकल 25 ही उड़ा दिया, आर्टिकल 21 ही उड़ा दिया. So 21, 25, 14, these have already been held to be basic structure. अब you getting my point? Then we'll see how. So right to property has been deleted. इसके पीछे की कहानी ये है. Okay, so please write article 19(1)(f), right to property. Abhi, there is a question, is prostitution justified through the right to practice any profession? We will see that when we do article 19(1)(g) of the constitution, that is right to practice any trade, occupation or profession. That is the next right. We must wait. Anjali Sharma is asking, we'll answer that. Okay, please write. Okay, so what did you write? Right to property has been deleted from article 19(1)(f). Right to property has been deleted by article 19(1)(f), and it is a constitutional right under article 300 capital letters 1 A. Sorry, who made this sound? I thought ki UPSC is inviting only citizens of India. Okay, so other species are also allowed. Okay, so please write. What did you write? Right to property has been deleted from article 19(1)(f), and it is a constitutional right under article 300 capital letters A. Okay, 300A capital jahan aaya, it is an amendment. Okay, ये सब full stop. आगे देखिए. This actually, if you are intelligent, 90 मतलब most of the questions you can answer सामने है. Sometimes they are trapping where they want you to attempt, but you should not attempt. If you complete your paper after 1.5 hours, they want you to attempt. उसका कोई आंसर ही नहीं है, इतना टफ है, you will not be able to answer those questions. You should. And how will you know that मेरा तुक्का रेट क्या है? This is a strategy. You have to find out what is your tukka rate. You will practice 30 papers. You will get absolute strict कि मेरा tukka rate क्या है. And same tukka rate would be there. The guess rate would be there in UPSC prelims. So you will practice 30 papers. You will get to know कि my tukka rate is this. If a friend of mine, he got 90 rank. So he actually, his tukka rate was absolutely bad. So he used to attempt 65 questions, 62 correct. So he knew कि मेरा यही है भाई, मुझे नहीं. There are people who are like एकदम अजय जडेजा. Okay. So even if they know 40 questions, they will attempt 100. Okay. Because you're getting my point. So UPSC में that you have to find out कि what is my guess rate. That is actually everything is a practice. Once you sit and practice papers, it is a factual statement. In 90% of the student, if you read all the book available for humankind on earth, you will not qualify prelims if you cannot practice papers. For 10% students, कोई जरूरत नहीं, उनका अलग level interview. Most of the students, you have to practice papers like anything. And that too in a conditioned atmosphere. You have to think that I'm taking prelims. 30 दिन तक you will practice papers and 31st day there is prelims. You are actually, your mind is absolutely ready for elimination, evaluation, getting the facts, uploading the facts, analyzing the fact, arriving at a right answer. You were ready. On 31st day you will feel मजाक चल रहा है. मतलब you will get at least 10 to 15 questions correct because you are into the habit of this. But you, what you do, ये बच गया, वो बच गया, आखिरी दिन दो पेपर के बीच में सीसेट क्वालिफाइंग के पैसे पहले देख रहे हैं परसेंटेज. सो नहीं, rather than going after an extra information, practice papers at the last moment. They will help you like anything. And best way is you practice UPSC papers of previous years. You practice, and Vision IAS test series, of course, that also you have to practice. So that is that too you will practice. That is the best. Okay. So the point is that you have to practice. At times some questions are like a bit tough. So abhi, you must have seen that movie Jigar. Usme he prepares them for a very hard battle. Then you get easy one. Practicing paper, get into the habit of 5 to 10 questions every day, consistently. There are students I know who have not even, they were preparing for mains till March. March mein gaye. This used to be the case till 2017. There are many students online, some toppers have also said, you can see. 2017, jaake 30, Vision IAS ka 67 questions were directly from test series. In 2067 questions were directly from test series. Okay, so that is a colossal number. Okay, so पर ऐसा नहीं है कि हर साल मतलब it is the, so if you practice papers, it is going to help you like anything. Okay, please write further. Huh? Okay, then you write, the remedy does not lie in Supreme Court. The remedy does not lie in Supreme Court under Article 32. Under Article 32. Pooja is asking, agriculture comes under state list, but why is central government brought farm bill? Entry 14 of state list is agriculture. Entry 33 of concurrent list is food stuff. Parliament can make laws on food stuff. So there is a clash between entry 33 of concurrent list and entry 14 of state list, which is agriculture. And surprisingly, entry 1 of 11th schedule also is agriculture. But to the extent decided by the state legislature, we'll see this. So, Pooja, the answer is कि while agriculture is a state subject under entry 14, entry 33 of concurrent list, where the parliament can make laws, talks about the right of parliament to make laws related to food stuff. So using entry 33 of concurrent list, parliament enacted 2 bills, one related to contract farming, other related to agriculture marketing committee. The third bill was food and civil supplies bill, that is essential commodities bill. 2 was presented by agriculture minister, 1 by food and civil supplies minister. All the 3 bills have been repealed by simple majority by the Parliament of India. Okay. So next you write, the remedy lies in, does not lie in Supreme Court, but lies in, अगर आपकी फंडामेंटल राइट वायलेट होती है तो आप कहां जाएंगे? You will go to Supreme Court if your fundamental rights are violated. If you're otherwise, you can also go to High Court. Okay, under Article 226 of the Constitution. So what was the statement? Please read out. The remedy does not lie in Supreme Court under Article 32, but High Court. The remedy does not lie in Supreme Court under Article 32, but High Court can issue a writ under Article 226. Can issue a writ under Article 226. High Court can issue a writ under Article 226. Okay, High Court can issue a writ, WRIT, under Article 226 of Indian Constitution. कोई प्रॉब्लम है इसमें? Okay, so Article 19(1)(g), to practice any profession, carry out any occupation, trade or business. You have a fundamental right to practice any profession, carry out any trade or business. अब आते हैं इसके restriction पे. Okay, so she's asking a question about prostitution. So this right can be reasonably restricted in the interest of general public. Reasonable restrictions can be imposed in the interest of general public. That is why there is a restriction. Okay, and the ab kya hai? I'll open a clinic at Old Rajendra Nagar and I'll write skin specialist, dermatologist. Okay, so do I have a medicine am I a medicine graduate? No, I'm not a medicine graduate. Am I a postgraduate in medicine? No. Am I enrolled with medical council? No, so I cannot practice medicine. So state can prescribe any professional or technical qualification for practicing any profession. So there can be a chartered accountancy, company secretary, you have FAI, then you have actuarial sciences, you know, actuarial sciences. It is related to investment, insurance, risk calculation, statistics, all these things are there, actuarial sciences. So किसी भी particular चीज के लिए you have to have qualification. Tomorrow you'll say that I'll practice in Supreme Court. You need to have a law degree. You need to be enrolled with Bar Council of India. Okay. So then अब ये देखिए, carrying out by state or corporation owned, controlled by state, any trade business. So state can restrict any particular trade or business for itself. Okay, आगे लिखिए, state can make any law related to carrying on by state any trade or business, whether to exclusion, complete or partial, or citizens or otherwise. मतलब समझे? वही तो बता रहा हूं, रुकिएगा तब ना. कहने का मतलब स्टेट टुमारो एक लॉ पास करेगा कि दिस पेंसिल विल बी मैन्युफैक्चर्ड ओनली बाय दिल्ली गवर्नमेंट. All this notebook, all the companies, okay, they will not manufacture. State can restrict any trade occupation for itself partially or fully. जैसे पहले banking sector, only public sector banks, no private banks. Aviation sector, only public sector airline, no private sector airline. Many hundreds of such sectors were exclusively reserved for government. So Article 19(1)(g) पहले कहता है you have a fundamental right to practice any trade, occupation, profession. फिर कहता है it can be restricted in the interest of general public. Then it says for any particular profession state can prescribe a technical qualification. If you want to be medicine practicing doctor, you have to have a MBBS degree minimum. Then it says कि कोई भी particular trade or occupation state can restrict only for itself. There were, if the state feels कि आज से बस सिर्फ state transport corporation की चलेगी, पहले सिर्फ SRTC ही चलती थी बस. So state can restrict a particular profession or for, you see it says carrying out by the state or a corporation, state का अपना कोई corporation, or controlled by the state, any trade, business, industry, service. So now the state is not doing this. State is restricted only into two areas. What are the two areas? Atomic energy or space. So these are the two areas which are exclusively reserved for the state. Otherwise, state has now opened every area. So otherwise, tomorrow if the state wants, can it do that? Yes. There are many cases, textbook corporation को लेके खासकर कि NCERT books है. Okay. So many textbook houses, publication houses or printing press, they have filed cases. कि we also want to publish the same. Okay. So our children would be studying. So if the state is doing that through a law, it is upheld. कि state can restrict any business only for itself. समझ रहे हैं ना इस बात को? So ये एक तरफ तो आपको fundamental right है कि आप कोई भी ट्रेड कर सकते हैं, ट्रेड ऑक्यूपेशन, बट दूसरी तरफ आपकी फंडामेंटल राइट स्टेट चाहे तो वो ट्रेड सिर्फ अपने लिए रख सकता है. सो दिस इज आर्टिकल 19(1)(g) एंड शी वाज आस्किंग अ क्वेश्चन इन द इंटरेस्ट ऑफ जनरल पब्लिक. दिस इज, अब आगे और सुनते हैं. बॉम्बे हाई कोर्ट सेज द मूवमेंट ऑफ प्रोस्टिट्यूट्स एंड एड्स पेशेंट कैन बी रेस्ट्रिक्टेड इन द इंटरेस्ट ऑफ जनरल पब्लिक if the state wants. So in the larger interest of society, most of the fundamental rights you see are individualistic in nature or society based. अच्छा, most of the fund, I have a freedom of speech and expression, तीन लोग मिलके एक्सरसाइज करते हैं. हाँ, I have a freedom to travel, तीन ही लोग चलेंगे, अकेले मैं नहीं चल सकता हूं. हाँ, so society सामाजिक rights हैं या individual rights हैं? Most of the fundamental rights are individual. Most of the DPSP, village panchayat, uniform civil code, early childhood care, most of the is environment, separating judiciary from executive, foster respect for international laws. Most of the DPSP are society, and many scholars say कि individual and societal rights are balanced by fundamental rights and DPSP. देखिए, actually अब थोड़ा इसमें deep नहीं जाना चाहते. There is a phase of Supreme Court. In first phase of Supreme Court, it is said that the Supreme Court has a phase. In first phase of Supreme Court was heavily inclined towards society. Okay, कि कभी भी जैसे कि किसी की जमींदार की जमीन ले रहा है, हाँ ठीक है. Getting my point? So article first constitutional amendment is okay. Society was at the base. After 1973, Supreme Court changed the gear. Now liberty, कि individual right to travel abroad, freedom of speech and expression to the maximum. So the Supreme Court changed its gear. कि नहीं, नाउ इंडिविजुअल इन वेस्टर्न, यही तो कहते हैं स्कॉलर्स कि वेस्टर्न सोसाइटीज में इंडिविजुअल सेंटर पे होता है और इंडियन सोसाइटीज में, हमारी सोसाइटीज में इट इज, क्योंकि इंडिया एंड जापान आर ट्रेडिशनल सोसाइटीज, यूएसए इज नॉट अ ट्रेडिशनल सोसाइटी. You don't know, this is a very factual term. With Japan, we have commonalities like both are net importers of energy, both follow parliamentary system, both have due procedure established by law, both are traditional societies, both are aspirants for UNSC permanent membership. So we have commonalities with Japan. USA is not a traditional society. In the sense कि values नहीं है, they are, कोई भी ऐसा value system नहीं है जो सब follow कर रहे हैं. So it is like tomorrow it's McDonald's, next it is Kentucky Fried Chicken, KFC, next it is, so there is no value based society. Our is a very traditional society. In China में तो और बुरा हाल है. China में just because of one child norm, a friend went to China, he says that वहां people don't have cousins. Don't have cousins, क्योंकि सब एक हो गया ना. Only one, so अब relative ही नहीं है, सिर्फ nucleus family है. People don't have cousins, either their parents have cousins, they don't have cousins, क्योंकि इनके पेरेंट को एक ही बचा हुआ और फिर getting, so now they don't, क्योंकि वन चाइल्ड पॉलिसी चल रही थी, अब ना किसी की मौसी है ना किसी का मौसा है, कुछ भी नहीं है. So he says कि a friend, he went to learn Mandarin, he said कि किसी को, he said कि दीदी या something in Chinese, so she became emotional, she invited कि you come for lunch. So getting my point now? So people are like, the society has become that ki one, just because of one child policy. In India, once they say कि we are leaving, gate पे 2 घंटा बात होती है. So once they say कि we are leaving, they gate पे they talk for 2 hours. Okay. So the point is कि we are that everything is guided by a custom. US में कोई custom नहीं है. You are getting my point कि मतलब whatever child is born, everything in India is guided by, they don't have so India and Japan, these are conservative traditional societies. Okay, so now we come back to this article 19(1)(g). So state can reserve any trade, occupation or profession for itself. Okay, please write article 19(1)(g) provides for, article 19(1)(g) provides for Article 19(1)(g) provides for fundamental right to practice any profession. Article 19(1)(g) provides for fundamental right to practice any profession, trade, occupation. Article 19(1)(g) provides for fundamental right to any trade, occupation, profession or business. Occupation or business. Okay? Then you write the state can reserve any, the state can reserve any The state can reserve any, see this, particular trade, business, industry, service. The state can reserve any particular trade, business, industry, service. Reserve any trade, business, industry, service. Partially or completely for trade, business, industry, service, partially or completely for itself. Very good. For itself. Okay. Now you write, the state can also provide professional or technical qualification. The state can also provide professional or technical qualification The state can also provide professional or technical qualification for carrying any occupation, trade or business. For carrying any occupation, trade or business. For carrying any occupation, trade or business. Okay, समझ रहे ना? Give me an example. Don't mind, you can sit here for the entire batch. I don't have an issue. CA for audits. Okay, so CA you have to, if you are claiming more than 50 lakh exemption, then CA से audit कराना जरूरी है. Okay. और कंपनीज जो है उनकी बैलेंस शीट पे सीए का साइन जरूरी है. एंड मेनी अदर company secretary also his signature is needed, and if you want to file a petition in court, you need to have a law. So these are professional qualifications. Okay, so you're getting it. So article 19 we have done. Okay, so A, B, C, D, E, F, G, H, okay, or only G. Okay, so what do you think about entire article 19? First thing is, it is only for citizens. तो फॉरनर तो बोले भी नहीं कि मैं घूमूंगा नैनीताल भी, जो सिटी वीजा पे लिखी हुई होगी वहीं जाइए. गेटिंग माय पॉइंट ना? एंड वीकली एफआरआरओ ऑफिस जाकर अटेंडेंस लगाइए. ठीक है. फॉरनर रीजनल रजिस्ट्रेशन ऑफिसर इन स्टेट्स वेयर यू डोंट हैव ऑफिस, एसएसपी ऑफिस नॉर्मली फंक्शंस एज. So foreigner does not have a right to travel throughout the country. He doesn't have a right to practice any profession. He cannot reside and settle in India. Actually, there was a case in United Kingdom, post retirement people were coming to Goa because the amount that they saved for in United Kingdom, that amount was not enough to buy a property over there. But here you'll buy property along with few okay, people to laugh at your jokes. Okay, why do you become IS? So that back jokes also people laugh. Sir, kya baat hai? So you are getting my point. So this is the thing. So the point here is ki I actually see this in a group. Like, it is not the joke which is important. It is who actually has posted the who have actually posted the joke, that is important. So the point is, non PT ka to joke koi nahi sunega bhai. So just kidding, ऐसा कुछ नहीं. You need to have talent. Whatever you do, you must be very happy. Believe me, literally I am telling कि you will feel on the ground. You can, all of you sitting in the class know so many bureaucrats in family, many of you have parents. Literally it is not that which you think. Because day before yesterday also I was at NASIN, National Academy of Customs, Indirect Taxes in Faridabad. It's not that. Services, especially in modern era, that whole babudam has gone. Too many restrictions are there. Of course, without a shadow of doubt, Indian Administrative Service gives you ample of option. It is one such coveted service that actually is very good. But it's not that people who are doing any other, so the way you imagine things are not like that. Believe me, it is too restrictive. You cannot leave your place, you cannot have time. You have all the time. So many of my friends, abhi closure chal raha hai, IRS IT, so it's like very hectic. You cannot visit places, you cannot meet people. If you buy anything, for everything you have to give record. So you feel yourself very And it is not that babudam anymore कि आप मतलब उतर रहे हैं कोई जूता पोंछ रहा है, like you see it is not that, but people have become opulent and they know. The friend of mine is DC, so he was telling people have become aware. You cannot just threaten a businessman anymore, and especially in the present government, so do not ever think. More than 25 IRS IT officers have been given compulsory retirement. एक मिनट गवर्नमेंट नहीं लगा रही है, IPS officers have been given compulsory retirement. Compulsory retirement. Administrative service, I don't know about that also, but it is not, whatever you do, you must be very good and you are doing that. Because it's not that cozy at all these days. Okay, it's not that cozy. Of course, in police service also, till the time you are, they know, till the time you are superintendent of police. So that is the most coveted. Otherwise, power nahi hai na police ko. Pen se, in India, in a democracy, pen, they don't have power na, pen mein koi power nahi hai. For an IS officer, difference between them is sky and the earth. Pen mein nahi hai na, civil officers have administrative, health, education, irrigation, transport, civil supplies, defense, communication. They have vast colossal powers in pen. While police service mein, you have to arrest him and place before the nearest magistrate. You cannot even issue a ration card. So on, theek hai, Munna would be afraid of you. In the locality, that is the only power. But on pen, you cannot bring any substantial change. You cannot give a old lady crying, you cannot give her a house. Okay, so you are getting my point. So pen mein to, it is the system in democracy is police does not have at all powers. At all. This must be understood at the onset. Pen mein, if you want robe, if power means to you that people should be fearful, of course, then police service, India mein to like SHO is so, but this pen may you cannot bring much change. You cannot bring much change. Of course, in civil service, administrative service, that is the thing. Anyways, so Article 20 can be classified into 4 parts. Okay, so we will just be Article 20 में we have this thing. First is 3 चीजें कहता है. No ex post facto law. No ex post facto law. मतलब no criminal law can be retrospectively applied. No ex post facto law. मतलब no criminal law can be retrospectively applied. Example, you slapped someone today. Today is 30th March 30th March, you slapped someone. The punishment for the offense of slapping is 2 days. Now tomorrow Parliament amends the law and makes that if you slap someone, punishment is 1 year. So the case will go on till April, May of any year. Okay, can be 1 year also. So 6 months, 3 months also. So the 31st of March, what you call the slapping incident took place on 30th March. On that day, the punishment for slapping was 2 days. So 31st March, if it is 1 year, it cannot be, any criminal law cannot be पीछे से applied, retrospectively applied. Classic example is that heinous incident happened, Nirbhaya. So you see, one of our sisters was like such a heinous incident happened, and there were 5 people. One person was minor. So on that day, child and adolescent labor and what you call the provisions of CRPC, IPC, anybody who is under 18 years of age, whatever crime he commits, he will maximum be sent to a reformation home for 3 years. So on 16 December 2012, when this crime was actually committed in South Delhi, at that time the law said that anybody who is 18 years, less than 18 years, any crime he commits, you have to actually maximum punish him for 3 years of reformation. Later on, the law was amended, and now you have what you call, if somebody who is between 16 to 18 years and commits a heinous crime where the punishment is more than 7 years, then there will be a board which will decide on the socio-economic background of the accused, that whether he will be tried in an adult court or in a juvenile court. Okay, so now the law has actually changed. On the circumstances of the accused, it will be taken that whether he should be sent to in a heinous offense, not in what you call where punishment is less than 7 years. Usko nahi. So now the point is, Nirbhaya's parents moved Supreme Court, that he was the main culprit. but Article 20 is the basic structure of the Constitution. It cannot be, in the sense that it cannot be suspended even during emergency. So Article 20 is the cardinal to democracy. So Supreme Court said that we have absolute sympathy, but we cannot apply a criminal law retrospectively. On the day when this offense was committed, the law provides that anybody who commits an offense, Indian Majority Act makes it 18 years for majority. If he is less than 18 years, he will not be sent to an adult court. He will be tried in a juvenile court where maximum punishment can be given is of 3 years. So in spite of the fact that Parliament amended the law, it cannot apply the law retrospectively because Article 20 cannot be breached. So criminal laws cannot be retrospectively applied. In one of the Hathi Corporation case, Supreme Court said civil laws can be retrospectively applied. Uska bhi example dete hain. For example, this is a country A. Country A mein there is a company 1, country B mein company 2, and country 3 mein country C mein company 3. Okay. So in country B, this is the name of the company. Okay. This company actually bought this company. This company actually bought this company 100% shares of this company. बस इतना समझ लीजिए कि जो ये नाम ही लिख देते हैं, इंडिया, नीदरलैंड. Now you see how civil laws are retrospectively applied. Or Cayman Island. Cayman Island. So there is a company in Cayman Island that is owning 100% share of Hutch in India. So Hutch's 100% shares are owned by a company in Cayman Island, and this company does not even manufacture a pencil. It is a post box company. Only job it does is it owns 100% of share of Hutch in India. इसको पेंसिल भी नहीं बनाना है, इसका नाम ही है पोस्ट बॉक्स कंपनी. इसको सिर्फ 100% शेयर ओन करना है हज का इंडिया में, और दिस इज इन अनदर कंट्री. Now this company wants, Vodafone wants to buy this company. Okay. So Vodafone thought that if I will buy this company, I have to give capital gains tax. Share transfer होगा तो tax लगेगा ना. So it did not do anything. It bought this company. Rather than buying this company, it bought this company and became the owner of this company. You are getting my point. Everybody is getting this. So ये company इस company के सारे shares को own करती है, तो Vodafone ने इसको ना खरीद कर, नहीं तो share transfer करना पड़ता, इसको खरीद लिया. 100% share owner हो गया. अब फिर गवर्नमेंट ऑफ इंडिया ऑफिसर्स, ओके, सो फिर नोटिस भेजा 7,000 करोड़ का टैक्स, कैपिटल गेन्स टैक्स, बिकॉज द शेयर वाज ट्रांसफर्ड, नॉट द शेयर वाज ट्रांसफर्ड बट कैपिटल गेन्स तो हो रहा है, तो टैक्स तो लगेगा. सो वोडाफोन चैलेंज दिस. पार्लियामेंट ऑफ इंडिया अमेंडेड इनकम टैक्स एक्ट 1961 इन 2011 और रेट्रोस्पेक्टिवली अमेंड किया 2007 से, जब ये डील हुई थी कि ऑफ कैपिटल गेन्स टैक्स वुड बी लेवीड ऑन एसेट्स इन इंडिया और वैल्यू which is derived from assets in India. अगर बाहर भी डील होती है लेकिन उसकी वैल्यू इंडिया से डिराइव हो रही है, तब भी आपको टैक्स देना पड़ेगा. सो दिस अमेंडमेंट वाज डन इन 2011, बट दिस वाज रेट्रोस्पेक्टिवली अप्लाइड फ्रॉम 2007 when the deal actually took place. So civil laws can be, prelims में there can be a question, civil laws can be retrospectively applied. पीछे से criminal laws cannot be applied retrospectively. दोनों का मैंने एक एक एग्जाम्पल दिया. Huh? Many other, for example, any law which can be civil law, motor law, vehicle act, any law can be पीछे से applied. just मतलब कि retrospective application. This also Supreme Court has said. Okay. Next is another question कि can the same person be punished for the same crime twice? So no. The same person once punished, he cannot be punished for the same crime twice, but there is no double jeopardy. But administrative action is not counted. Example, there is an IS officer, he commits murder. So there will be two things. One, he will be expelled for committing murder, IS officer, and then he will be subjected to IPC 299 which defines murder, and 302 which prescribes punishment for murder. So this will not be counted as double jeopardy. कि वो बोलेगा मुझे नौकरी से भी निकाल दिया, आप जेल भी भेजोगे. ऐसा नहीं होगा कि no double jeopardy in administrative actions. So administrative actions are not counted in double jeopardy. You cannot be punished for the same crime twice, but that does not include an administrative action taken by your department. That is the second. So first point of Article 20 is no ex post facto law, no criminal law can be applied retrospectively, but civil laws can be applied retrospectively. No ex post, no double jeopardy, and no self incrimination. This is a very, very contentious issue. There are hundreds of judgments of Supreme Court. What constitutes self incrimination? Self incrimination का simple मतलब है you cannot be forced to be a witness against yourself. So two questions I will take you up. वही ना law की बात. There is one person in one of the famous cases. One person said that I have committed the murder and I have hidden the weapon over there. I have committed the murder and I have hidden the weapon over there. This he said in police custody. And this became a basis for his conviction that I have committed the murder and I have hidden the weapon. The case went to Supreme Court. Supreme Court said first part of the statement that I have committed the murder is violation of Article 20 because such a statement was given in police custody. Second part of the statement that I have hidden the weapon over there, this police has to prove that that weapon was used to kill the person. So no statement that is given in police custody is admissible as an evidence under Indian Evidence Act 1872. Yani aap nahi. You cannot be, but the Supreme Court so many cases says. Another case is their Rohit Shekhar case. One of the persons of leading politician, a person claimed that he claimed for himself that he is the illegitimate. There is no illegitimate child. पहले तो फर्स्ट है, क्योंकि there is no illegitimate. Every child is a biological child. He will get equal property as per Indian laws. So there can be a child out of marriage, wedlock, and there can be a child out without marriage or wedlock. But there is no term like illegitimate, which is a societal term. Before law, every child is a biological child, has all the rights of the property. So somebody claimed that he is the child of a famous politician. Okay, this is a very famous case. Many of you must have heard also. Child of a famous politician. So his mother, he claimed that was in a relationship. Shadi nahi hui, but he is the child. So the point is, so Delhi High Court ordered that politician to share DNA sample. He challenged that Article 20 of the Constitution, you cannot force me to give my DNA sample. Finally, Delhi High Court ordered that DNA sample has to be given. And in DNA sample was given and paternity was actually established. And he got all the property share, although the person died within 2 years. Okay, so this was a what you call this thing. So the point out here is कि DNA samples in rarest circumstances can be forced. Narco analysis test cannot be accepted as an evidence individually. There are circumstantial evidence, this may adduce to that, but that cannot be. Thumb impression, blood specimen, handwriting, ये तो देना ही देना है. नहीं, मैं handwriting भी नहीं दूंगा. तो फिर constable will take, okay, he will take the charge. Okay, I will. You are. What he'll do? He'll give you to eat so many things. But he'll eat and he will not give you water. He'll put you inside. If you are 5'8", he'll put you in 5'4" box. So you'll immediately sign and give everything. Okay. So the point is कि handwriting, what you call thumb specimen, these can be given. DNA in certain circumstances can be given. Narco analysis independently is still not available. There are different. अच्छा, अभी conclusive judgment होता है. एक high court ने कुछ दे दिया, दूसरे high court ने कुछ judgment दिया. Different high court. One judgment of one high court has persuasive value in other high court. It does not have binding value. So a conclusive evidence कि whether WhatsApp conversations can serve as an evidence is yet to be. It's a final judgment is yet to be there. Okay, it's not an issue over here also. So Article 20 says three things. One, no criminal law can be retrospectively applied. Second, no person can be punished for the same crime twice. This is double jeopardy, and no self-incrimination. You cannot be forced to be a witness against yourself. Finally, somebody goes to the court before magistrate and says, I have committed the murder. What should the court do? Court will accept his submission and proceed accordingly, or his submission will not be accepted. अच्छा, क्यों? कोर्ट के सामने बोल रहा है, फोर्स नहीं कर रहा है, पुलिस के डंडे के सामने नहीं, कोर्ट के सामने. Before the magistrate says that I have committed the murder. So can self-incrimination, you cannot be forced to be a witness against yourself. You can be voluntarily, zamir जाग गया, He murdered the killer of his parents, and then Dharmendra goes there and says ki, yes, I have committed the murder. So actually होता है ना कई बार. So what is the duty of court? Self incrimination will be applicable in confession or not? Huh? It is the duty of court to authenticate and verify and the veracity of the statement, because celebrity X kills 5 people and the driver of celebrity X comes and says that I have committed the offense. So the court, what will the court do? Court has to authenticate, verify the veracity of the statement. So self-confession also has many aspects. I don't want to go deeper into that. Under Indian Evidence Act 1872, self-confession भी certain circumstances में ही accept होगा. ये नहीं कि कोई किसी ने मर्डर किया, उसने उसको दिया कि बाहर रह के तू कितना कमाएगा, मैं देता हूं पैसे, घर वाले भी खुश रहेंगे, बटर चिकन खाएंगे, तू भी चलो WhatsApp कॉल करा देंगे. Getting my point? So he will say, and he is like, chill out. He will commit again, and he'll send another driver. Okay, so the point is, कि self-confession is also not admissible if it is not true. Okay, so please write Article 20 of the Constitution. So एक second, थोड़ा इन लोगों को देखें. Criminal Procedure Act is in news. Actually, the Honorable Home Minister is proposing to amend IPC. Actually, a friend of mine, he is an assistant professor in one college, and the owner of the college is an MP of Bharatiya Janata Party. All the MPs have been sent by Ministry of Home Affairs to give their opinion on the comprehensive overhaul of Indian Penal Code 1860. आप Indian Penal Code 1860 पढ़ेंगे, you will be shocked. For example, the way they have defined an offense, after 150 years, it is still relevant. So it is such beautiful word selection. Now we want to, because it's been long time, so we want to amend CRPC and IPC, especially IPC. There is a talk going on that we will be amending Indian Penal Code, okay, comprehensively. Okay, many Criminal Procedure Act is in news. Okay, example of double jeopardy can be taken from Andha Kanun movie. Okay. Vodafone case retrospective taxation yesterday. अब ये बोल रहा है how it violates Article 20 Criminal Procedure Identification Bill. So how it violates Article 20? अरे एक्ट थोड़ी वायलेट कर, रेट्रोस्पेक्टिव एप्लीकेशन है. एक्ट अभी आ रहा, अब जो नया क्राइम करेगा उसको, जिसने पीछे कर लिया क्राइम, getting my point? So criminal laws क्या, हाँ, can criminal laws be amended to give you relief? Yes, criminal laws can be amended to give you relief, but it cannot be amended to make it things tough for you. Please write Article 20. No ex post facto law. No ex post facto law. What is the difference between advocate and lawyer? Advocate is the one who has the right to practice on someone else's behalf after getting enrolled and after graduating in law, getting a degree registered, he is an advocate. Lawyer is the one who is a law graduate or a student of law. Normally a law graduate you take, but he does not have a right to practice. First you take degree, then you enroll yourself with bar council, then you become an advocate having right to practice on someone else's behalf. Okay, so please write no ex post facto law. Ex post facto law. No criminal law can be retrospectively applied. 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 Full stop. Civil laws can be retrospectively applied. Civil laws can be retrospectively applied. Okay. Later on you write, no person can be inflicted a punishment. No person can be inflicted a punishment. No person can be inflicted a punishment greater than what the offense provided for. No person can be inflicted inflicted, 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 a punishment greater than what the offense provided for, greater than what the offense provided for on the day of, greater than what the offense provided for, greater than what the offense provided for on the day of commission of crime, on the day of commission of crime. On the day of commission of crime. Then you write the Supreme Court in Hathi Singh Manufacturing Corporation case, the Supreme Court in Hathi Singh Manufacturing Corporation case, the Supreme Court in Hathi Singh Manufacturing Corporation case ruled that civil laws can be retrospectively applied. Civil laws can be retrospectively applied. Then you write no double jeopardy. No double jeopardy. No double jeopardy. No person, no double jeopardy. No person can be punished for the same crime twice. No person can be punished for the same crime twice. No person can be punished for the same crime twice. Next you write the departmental or administrative action, the departmental or administrative action the departmental or administrative action as they are not of judicial nature, the departmental or administrative action as they are not of judicial nature, the departmental or administrative action as they are not of judicial nature are not covered in double jeopardy, are not covered in double jeopardy. Please write no self-incrimination. No self-incrimination. Please write no self-incrimination. Please write no self-incrimination. लिखिए no person can be compelled to, no person can be compelled to be a witness against himself or herself. No person can be compelled to be a witness against himself or herself. Please write later, self-incrimination does not include, self-incrimination does not include signature writing specimen, self-incrimination does not include signature writing specimen, thumb impression, etc. Signature writing specimen, thumb impression, etc. Signature writing specimen, thumb impression, etc. Later on you write the Supreme Court in, this is a very famous case actually, Nandini Satpathy case. Nandini Satpathy. Nandini Satpathy case, SATPATHY. Satpathy. SAT, Saturday wala Sat, PATH, path wala Y. Okay, Satpathy, Nandini Satpathy case, the court widened the scope of widened the scope of the court widened the scope of self incrimination and the court widened the scope of self incrimination and included mental pressure also in it. Okay, अब I was expecting a question, वो आ गया question. Okay, if a law comes to reduce the punishment of an offense but the offense was done earlier, then it will be applied. Now you will see the constitution. Now you will answer on your intellectual understanding of the statement. Then you will be in a better position to answer. आप बताएंगे मुझे, ठीक है? क्या कोई लॉ जो किसी क्राइम को नॉर्मली ऐसा होता नहीं है, इनहैंस करते हैं, punishment is enhanced, it can very rarely it is reduced. If it is reduced, it says no person shall be convicted of any offense except for violation of a law in force at the time of commission of that act, charged as an offense, nor be subjected to a penalty greater than what might have been inflicted under the law at the time of commission of the offense. इससे क्या मतलब है? What does this mean? You read this article for paragraph 1. No person shall be convicted of an offense except for violation of law. Law ही violate करेगा तब, or greater penalty than what it was at the time of commission of offense. So can a law which has diluted the offense punishment can be retrospectively applied? It is only prohibited. Greater punishment नहीं मिलेगा. कहीं नहीं कह रहा है कि कम punishment, पर there are actually few पेचीदा laws, complex laws. Somebody was convicted. There is a difference between sentencing and conviction. First you are accused, then you are found guilty, that is conviction. Sentencing is क्या punishment मिलेगा. कई बार after conviction you are let off. You are found guilty, ₹1 का punishment, but you are found guilty. So you were convicted of that offense, but you were not sentenced. Okay. So now the point is, you please just tell me one important thing. Ki now somebody was awarded punishment, and after that, see how they have termed it, awarding punishment. So this is the language of the text. It says awarding punishment. Who will be happy to get punishment? फांसी सुना दिया, ah, मजा आ गया. They cannot do like this, right? Awarding punishment. Okay, it is like the Britishers, they write, they feel you, they try to feel you good even if you are in the pain. Okay, by writing awarding punishment. Okay, so no person who is awarded a punishment, okay, actually later on the law reduced the offense, matlab punishment. So he approached the court. Court ने कहा नहीं, ऐसा नहीं चलेगा. When the conviction was announced, at that time if the law would have been changed, अब आप जेल में already हैं, and now you are claiming that पीछे से जाके मेरा conviction को change कीजिए. So that is the liberty of the court. That हाँ, if the case is going on and the law reduces the punishment, then you will get the benefit. You will get the benefit, but you will not get the matlab the harm thing of it. You will get the benefit to the best. Okay, better than expected. Matlab वो मिलेगा. Court will give you. Okay, so this is done. We will be starting with Article 21. We have a class tomorrow. No, we don't have a class tomorrow. Okay, fine. अच्छा किसी और बैच में है तब. ठीक है. So we will be doing Article 21. That is right to life. Very, very important. Passive euthanasia, active euthanasia, right to reputation, health, clean, all the things will. अरे भैया 2 मिनट रुक जाइए. हद है एकदम. हाँ 1 सेकंड बोलिए. मतलब if you are forced to give signature or writing specimen, it will not be counted as self incrimination. उसके लिए कोर्ट आपको फोर्स कर सकती है. ठीक है. हैव अ वंडरफुल इवनिंग. टेक केयर.